we are live, sir. We are reaching a number of participants.
Hello all, a very good morning, good afternoon, good evening to all the attendees who have joined the KFCRI webinar series from different parts of the world. Myself, M. Sri Nikila, on behalf of the Managing Committee of KFCRI, is taking a great privilege in welcoming you all to this webinar session on ethics of arbitrator. I would also like to extend my soulful welcome to Mr. Muthupandi Ganesan, the lead panelist in this session. This session will be moderated by Mr. Kavin, a Research Associate of KFCRI. And also with us, we have Mr. V.Inbavijayan, the Project Advisor as well as the backbone of KFCRI. Before starting the session, I would like to introduce KFCRI to the attendees from across the world. Kovise Foundation Conflict Resolution International is an ADR institution and an accrediting body. As an ADR institution, KFCRI has its own tailor-made arbitration, mediation, conciliation, negotiation, and even tribunal secretary rules. KFCRI also takes up the role of an appointing authority in which it appoints many arbitrators in many arbitration cases. As an accrediting body, KFCRI provides trainings to practitioners, professionals, individuals in the ADR arena of arbitration, mediation, conciliation, negotiation at different levels like associate, affiliate, and fellow. We also provide membership under the exemption category to professionals who have pioneered in the paradigm of alternate dispute resolution for over many years. For further details regarding membership, training, and KFCRI, you can reach us at www.kfcri.org. Now, moving to the housekeeping rules, today's webinar session is a session of 1 hour. The first 30 minutes will be a presentation session by the lead panelist on the topic ethics of arbitrators, followed by which the next 15 minutes will be an interactive session between the moderator and the lead panelist. The last 15 minutes is reserved for Q&A session in which the lead panelist will answer the questions posted by the attendees. The attendees can post your questions at the Q&A box below. We kindly request the attendees to refrain from posting your questions at the chat box. For any technical difficulties with regard to the audio or video quality, you can reach us through the chat box. We will try to get your questions answered as much as possible. In case if any of your questions remain unanswered, you can write us at kfcri.adr@gmail.com. Without wasting much time, I would like to request Mr. V.Inbavijayan to inaugurate the session by welcoming the lead panelist.
Thank you, Srinigila. Good afternoon for Indian audience and good morning to Mr. Muthupandi Ganesan. It is a privilege to introduce today's panelist, Mr. Muthupandi Ganesan, a good friend and arbitration practitioner based in two jurisdictions. Obviously, he is a barrister-at-law in England and Wales, as well as he is an advocate enrolled in the Madras Bar. And I'm very much interested to bring Mr. Muthupandi Ganesan to all of you, who is very interestingly practicing as an arbitrator and mediator. It's a combination of different activities combined together to one. Initially, when I happened to meet Mr. Muthupandi Ganesan, he was actually practicing into the criminal law, and many cases he was dealing with anti-money laundering. And of late, he has just become exposed to arbitration, and now he is totally concentrating in arbitration and mediation, not only in these two jurisdictions like India and UK. He is also concentrating in many jurisdictions like Nigeria, Isle of Man, Bermuda, as well as the Gibraltar, all the tax havens. He is doing a lot of activities involving arbitration and mediation in all these jurisdictions. To his accreditation, he is a fellow of Chartered Institute of Arbitrator, and the greatest accolade is that he is a member of Worshipful Company of Arbitrators UK. It's a very it's a group of peer arbitrators who have been inducted as member. He is one among the member of the Worshipful Company, and recently he is also a member of the Society of Mediators UK. To add on, I can add many things to his profile. But if I'm just going to continue, then Mr. Muthupandi can't share his allied thoughts about ethics of arbitrators, which is most essential out of the whatever the webinars we have done. This is a prime thing. We have given all the dosages. Now, all the dose has to be going with along with the values. Without the values, you can't just act any role, whether you are an advocate or whether you are an arbitrator or mediator. We should have the moral values. That moral values is going to be highlighted by Mr. Muthupandi Ganesan today in the topic of ethics of arbitrators. And on behalf of KFCRI and my team, I put forward the welcome note and hand it over to Mr. Kavin to take it forward.
Thanks to Mr. Inbavijayan and Ms. Nikila, and I'm very warm welcome to Mr. Muthupandi Ganesan and all the attendees varied from all over the world. A very good morning, good afternoon, and good evening. I'm glad here to moderate this session to give brief introduction to the topic to know about the ethics of arbitrator. Mr. Muthupandi Ganesan defining what is the essence of arbitration and arbitrator, and then moving on telling about the arbitration code of conduct on international guidelines, and then explaining about the main part of topic about the traffic signals and the 3 list. Last but not least, Mr. Muthupandi Ganesan addressing on impartiality and bias with citing some landmark cases. So I would humbly like to ask his views on ethics of arbitration. Sir.
Ladies and gentlemen, good morning to you. I hope you can all see me and hear me well. It's a bright morning in London, and as anybody knows, if you live in London, the first thing you talk about is the weather. And I'm pleased to say that we have got a nice, bright, sunny day here. But more importantly, may I say thank you to Mr. Inbavijayan and his wonderful team for inviting me on this excellent webinar series. I know they had some wonderful speakers before me, and I'm delighted and honored to be able to address you all, and particularly KFCRI team and its members. I'm delighted, and thank you for the wonderful introduction earlier by Mr. Inbavijayan. As he mentioned, I have started my journey as a barrister doing litigation, and particularly a lot of international white-collar fraud type work. But now I focus very much on arbitration, both domestic and international arbitration. And I'm delighted to be able to actually talk about an issue that, in my view, is the most critical issue as far as arbitration is concerned. And I'm just going to share my slide show with you, and I hope you'll be able to see that. And I'm very happy to be able to talk about this particular topic, which in my view, as Mr. V.Inbavijayan said, in arbitration, you have many aspects of arbitration, which deals with procedure, which deals with the conduct of arbitration, which deals with the outcome of arbitration. But what I want to really focus on, and I hope in the very short amount of time I have, on three particular issues, if I may. First of all, I would like to look at what does it mean in terms of introduction, essence of arbitration and arbitrators, and what's the link between the two when we talk about arbitrator ethic. And second topic I would like to touch upon briefly is look at the various international guidance on what is the appropriate standards, expectations, norms in terms of a person conducting arbitration. And the third area that I would like to, again, to just touch upon briefly is what are the challenges that are often brought about by parties to an arbitration in challenging the way the arbitrator has conducted himself. And those are the three areas I will look at briefly in the time that's given to me. Now, let me start with the essence of arbitration and arbitrators. It's crucial to understand the way the mechanics of arbitration works, because if only you understand how arbitration works, you'll be able to understand what is required of an arbitrator. I have put up on the slide an old case, a 1968 case from America, but in my view, demonstrates the importance of the topic that we're talking about. And the quote that I put up for you is worth just reflecting for a few seconds. It's this: we should be even more scrupulous to safeguard the impartiality of arbitrators than judges, since the former have completely free rein to decide the law as well as the facts and are not subject to appellate review. Now, that is a very powerful statement, which basically says, well, actually, the safeguards that needs to be put in place for an arbitrator is greater and more required than of a judge. And why do we say that? And in order to understand that, you have to look at some of the key criteria of what forms arbitration and where does the arbitrator sit within that formulation and sit within that process. We're all, as arbitrators and arbitration practitioners, often used to hear the word party autonomy. And party autonomy means arbitration is driven by parties. It is not a claim, or it is not a case that is brought by a state against the individual, for example. But you can do that, and those are investor-state arbitration and so on, but generally distinguishing between a state-controlled process as opposed to two parties who are at liberty to conduct their affairs, usually business people, conduct their affairs and resolve their conflict. And how do they do that? And one of the key criteria under the New York Convention, which you'll all be familiar with, but I have put it up there for you, is Article 5.1d. And why is that important, you may say? It's important because it's very clear it's no good going through the whole arbitration process where two parties spend time, effort, energy, money, and going through the legal process in an arbitration setting, then only to find actually the award, which is what is called when a judgment is given between the parties in arbitration, the award is not enforceable. And one of the main criteria is that recognition and enforcement of the award may be refused at the request of the party against whom is invoked, only if that party furnishes to the competent authority where the recognition and enforcement is sought, means in whichever country you're trying to enforce it, proof that the composition of the arbitral authority or the arbitral process was not in accordance with the agreement of the parties. So it's really, really important when we look at arbitration, arbitrators, and ethics, also to understand the composition itself in the first place has to be in accordance with the agreement between the parties. And often mistakes can happen where the arbitration clause clearly says it requires 3 arbitrators, and if you only have 1 arbitrator, for example. So these are the procedural composition issues that one needs to be absolutely careful about. So party autonomy is what starts this process. It's what gives life to arbitrators to be able to be involved in a case or involved in a dispute. And this goes to what I've already mentioned, is the difference between a contractual appointment by parties as opposed to a state appointment of a high court judge or any form of adjudicator by the state. And often in many countries, the level of giving an award in a dispute often is recognized as quite a high level, generally tends to be at a high court level, rather than much lower, so magistrate court in that sense. And secondly, and most importantly, arbitration process is not subject of appeal. Of course, in life, there are always exceptions to a rule. And one of the exceptions in arbitration setting is there are some cases where we have had multi-tier arbitration clauses. And there has been a very famous one recently with arbitration in India, followed by a second process in London. But those are exceptions rather than the norm. But the whole purpose of arbitration is that it allows parties to be able to get out of the dispute quickly without going through this long, drawn-out process of appeals and appellate mechanisms, which often comes with the state process. And the third point is everybody wants to do this because it's often, or actually, at least it should be, it's more economical, it's more efficient, it's cost-effective. I know there are many people who practice in arbitration say that, in fact, arbitration has now become too expensive, but that's a different topic and that's a different issue. I'll leave that for a moment. The other point, of course, it's an important one because it applies not only to the parties, but it applies equally to the arbitrator. And what is that? And that is the issue of confidentiality. Confidentiality is a key criteria for the parties involved to make sure that if they're involved in a high stake, sensitive, for example, IP dispute, you don't want the whole market to know there's a dispute on that. So that you go through arbitration process as a way to keep the dispute under wrap. Whereas in a public court, you won't be able to do that. But now with arbitrator ethic, it is just as important for an arbitrator to ensure that he keeps material, he keeps the process, he keeps his involvement as well confidential, because those are very important to the parties. And the other reason why arbitration is so critical, particularly in cross-border legal disputes, commercial disputes, is that often you have parties sitting in different places, or at least manufacturing in one country, supplying in a different country, actual agreement taking place in different countries. And each country may be very different in its ethos, in its procedure, in its setup, in the way it operates. And just to give you some wild comparisons, you can compare London with Dubai, with Zimbabwe, for the sake of argument. And you can see how difficult it becomes. And that's one of the reasons why arbitration is so valuable. And that value can only be added and properly protected if the arbitrator is able to actually perform his or her role properly. And that involves, as we know and we understand, ethical consideration by the arbitrator. The arbitrator has to behave, when we say ethically, morally and fairly and properly. And we'll look at those sort of terms shortly. But to start off with, where does the arbitrator get his or her initial guidance on what is it actually expected of them in terms of arbitrator ethics? And in my view, a good place to start is the UNCITRAL model law on international commercial arbitration, with the revised code in 2016, the original being in 1985. And it's really important to understand the key criteria that's been laid out in Article 12, which is titled as grounds for challenge. And it deals in two parts, really. First part, I would categorize as the disclosure requirement of an arbitrator. And what is that disclosure requirement? And it's very clear and it's quite explicit in the way the model law is set out. Where a person is approached in connection with his possible appointment as an arbitrator, he shall disclose any circumstances likely to give rise to justifiable doubts as to his impartiality or independence. And that's the key. So you as an arbitrator, if somebody approaches you, you're duty bound to say and disclose and provide and give that assurance of any circumstances that is likely to give justifiable doubts on impartiality, independence. And often words such as bias is used. Impartial means effectively being fair, those sort of the words that's impugned in Article 12.1. So that's the first disclosure element. And what then the model law goes on to say, an arbitrator from the time of his appointment and throughout the process shall without delay disclose any circumstances to the parties unless they have already been informed of them by him. So what that means is that that disclosure obligation is from the outset, from the prior engagement to the engagement through the process until the end of the arbitration process in that particular instance. On Article 12.2, again, is very explicit, and it says, an arbitrator may be challenged only if circumstances that exist give rise to justifiable doubts as to his impartiality or independence, or if he does not possess qualification agreed by the parties. Well, you may think, well, actually, that's quite obvious, isn't it? If you're going to be an arbitrator, you must be qualified to be an arbitrator. And you must think, well, this has been around since 1985. Surely we still can't have cases where a person who's sitting as an arbitrator doesn't have the proper qualification. Well, I will show you, these are still live issues. And I'll show you a very, very recent case where an arbitrator who arbitrated the case, took the appointment, was in fact found not to be qualified in that sense or have the experience to be able to arbitrate in a case. And that is as recent as last week. And I'll come on to that a little bit later. And the first part of Article 12.2, again, is clear, isn't it? It says, if there is justifiable doubt on impartiality or independence, and those are the only grounds on which there could be a challenge. Now, where do we get the international guidance from? Well, you will see here, there are many, many arbitral institutions in the world. I have only picked up 4 of them, and those are 4 that I know well and have done cases on, and I thought it'd be interesting for you to refer to them as and when you need to. But they all have very, very similar scheme and similar ethos in the way they expect arbitrations to be conducted in those arbitral institutions, which of course is the difference between an ad hoc and an arbitral one. And the arbitral one here, for example, the first one is the Singapore International Arbitration Center guidelines, rules. Look at Rule 13. It's about being qualified to be able to do the arbitration. Rule 14 deals with challenges to arbitrator. Okay. Then if you move on to the second one, which is the LCIA, that's the London Court of International Arbitration. Again, Article 10.2 is very clear. You, as an arbitrator, must act fairly or impartially, or does not conduct or participate in arbitration with reasonable efficiency, diligence, and industry. What that means is that these are your duties as part of your ethical consideration. Not only do you need to be fair and impartial, but also engage in the process, be diligent, and deliver what you've been asked contractually. And we'll come back to LCIA shortly. There's a little bit more guidance in the next slide. And the next couple of slides. And third one, which I wanted to highlight to you, these are the ones you'll be familiar with. And these are often known as the traffic light or traffic signal type scenarios. And these are International Bar Association guidelines on conflict of interest in international arbitration. And this is an excellent guideline, and I would urge you to read it if anybody hasn't seen it. And it's divided into two parts. Part one, which is the general standards regarding impartiality, independence, and disclosure. And part two is the one with the traffic signals, which people are often refer to. That's the red, orange, and green type situations. And those are the situations that often different parties in different jurisdictions look at that. You have certain category of items that are non-waivable red list. Then you have potential waivable red list. Then you have the orange list, and you have the green list. And these are guidance that's been provided to parties so that they can consider whether it is a situation that in fact gives rise to particular challenges to an arbitrator's role within an arbitration. And as I say, it's very easily readable, it's well written, and you can follow the different types of instances that's been given there. I won't take too much of the time going through them because I've got very limited time. And it's certainly something I urge you to look at, please. Now, the other institution where I'm a fellow of is the Chartered Institute of Arbitrators. Again, their rules and again, their standards and their training always focuses on impartiality and independence. Okay, and if you look at Article 11, deals with disclosure, and Article 12, I have again highlighted here for you, which deals with Article 12.1, any arbitrator may be challenged if circumstances exist that give rise to justifiable doubts, again, as to impartiality or independence. And the second part, a party may challenge the arbitrator appointed by it only for reasons which it becomes aware of after the appointment has been made. And thirdly, in the event the arbitrator fails to act, or in the event of de jure or de facto impossibility of his performing his or her functions. And that deals with illness and inability. And one of the great things now we have is, for example, lockdown, pandemic, and there have been many arbitrations which have sort of stalled. Yes, there has been use of electronic means of communicating, electronic means of having a hearing, but that is, of course, is not as satisfactory or as likable for many other practitioners as doing it online through Zoom or other Microsoft Teams, whatever the platform that you use. Now, so what are the key ingredients for an ethical behavior by an arbitrator? And as I mentioned earlier, this is the guidance note I was referring to. And this has got a very clear, easy to understand and follow guidance and pointers. And I just would like to take a minute or so to go through that, if I may. Notes for arbitrators, part 2, independence and impartiality. This is what is expected of arbitrators: to disclose possible conflict of interest at the outset, to avoid putting yourself in a position where conflicts will arise during the course of the proceedings, to conduct the arbitration fairly. And here you use the word fairly, which is different to the words you've seen earlier: impartial, independent, fairly, in a timely manner with regards to the due process. Again, goes to the point about justice delayed justice denied in terms of the longer you take to deliver a judgment, for example. It has impact on the parties and maintain confidentiality. And the last one, to reach decision in an impartial manner, and that goes to that independent requirement. Okay. Now, one of the greater observations was made by Lord Hope in the case of Porter and McGill, which was a 2002 English case. But it's a very good summary, in my view, of what is expected of a person such as an arbitrator performing his or her role, whether the fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased. So when you look at how the arbitrator is behaving, it is an fair-minded, informed observer test, i.e. the independent person, or English lawyers often use the word, a person sitting on the omnibus, sometimes is used to say, well, actually, when a person who knows about everything of a case, what would they think? And I just want to run through some cases quickly in the time that I have got left. Not much time, but these are some cases which I can give the link to in due course, which are very useful consideration. Here's a case of Argonaut Insurance Company against Republic Insurance Company, where the court was faced with a challenge in relation to an arbitrator who gave a witness statement on another matter in relation to a contractual clause. As you can see, it's an insurance case, it's an insurance clause. And where the court went on to say, David Steele, Justice, held that, I do not regard the fact that he, being the arbitrator, has stated in a statement in another arbitration an opinion about the meaning of a clause when he was to be called, if he was to be called or told as a witness of fact, carries with it any implications as to his impartiality. It seems to me there are no adequate grounds to conclude there is any real possibility, objectively perceived, for a fair-minded and informed observer to conclude that there's a real possibility Mr. Simons is biased. So as you can see, just because you gave a witness statement in a different case on a pure contractual analysis of a clause does not mean you're biased. Okay, now another case, Coughley against Bingham. This is a very famous case because this is in relation to an arbitrator who was engaged often by a same company or individuals or a source of work. And that was held by the court to be problematic. Justice Hamblin, now he's Lord Justice Hamblin, what the court said was, arbitrator must disclose all interests, relationships, matters likely to affect the member's independence or impartiality, or which might be reasonably perceived or likely to do so. So can you see that there are different aspects to that, but what is clear is it is an individual consideration, fact specific, and it needs to be looked at it, but the arbitrator must disclose all aspects. There's another case where in fact the arbitrator was at least held to be biased and was removed. Is in the case of Sierra Fishing Company against Farron, which is a 2015 case. Again, Justice Popwell removed an arbitrator on the basis that a fair-minded observer would conclude that the connection between the arbitrator and the law firm in which he had financial interest. So this is nothing to do with how he conducted the arbitration. It is the mere connection with the law firm was sufficient to at least give rise to a real possibility that the arbitrator would be potentially biased. So you can see how wide these things can be and how easy it is for an arbitrator to actually go wrong and make mistakes in terms of his role. Now, there's one other case which I'd like to show to you, is the case of Halliburton Company against Chubb, again an insurance case, but it's a very important insurance case. And in this case, this is where the court gave really good guidance on how an arbitrator should behave when there are overlapping arbitration cases where the arbitrator is involved. And the court went on to say arbitrators are assumed to be trustworthy and to understand that they should approach every case with open mind. And this is a key criteria. The mere fact of appointment and decision-making in overlapping references does not give rise to justifiable doubt. So what the court is saying that if you're appointed an arbitrator, there is an onus, duty, as well as trust by the public on you that you will deliver your judgment and your efforts in a proper, open-minded manner. Objectively, this is not affected by the fact that there's a common party. An arbitrator may be trusted to decide a case purely on evidence and material before him, and equally, even if there's a common party. There are three other cases before I stop. I think I'm running out of my time. First case is a very recent case, C Limited against D, and this only happened last week, I think 21st of May in London. An arbitrator was removed as he did not have sufficient experience and expertise in relation to a particular case. So he agreed, he took on the appointment, and this was an arbitral institution appointment, that's the LCIA. Even then, he was found not to have sufficient experience. In a slightly different context, I put in another case of Rabbi, Dowden, and Bitten. And this is in relation to a Jewish rabbinical court, where a judge who was giving a award in that court failed to tell the parties that he had a discussion with the respondents to the case about when the timing of the award is going to come out. And something as innocent, something as mundane as that can give rise to complaints, can give rise to potential bias and impartiality. Thankfully, in this case, the court, which was a December 2019 case, the court said, oh, actually, there is no bias here. There is no justifiable doubts in relation to the arbitrator's act and his role. Now the final case, which I'd just like to highlight to you again, is a very recent case, where, again, a challenge about an approach comes to an arbitrator whilst he's arbitrating one matter by one of the parties in relation to a completely separate matter. And as you can see, this is an investment treaty arbitration between Tatneft and Ukraine. And whilst that's been happening, the arbitrator was approached in relation to a completely separate, non-related port dispute against Peru, and in a different country, of course. And the court said there is no bias. And so when one looks at bias, it's very broad, it's very easy to go wrong, and it is very, very fact specific. And this is the things that arbitrator must have to his mind when he's involved in arbitration as the arbitrator. Now, what are the other ethical considerations for arbitrators? Because I only got 30 minutes, there are many, many areas that you could talk about on arbitrator's ethic. As Mr. Imbavijayan said, this is the most critical area of arbitration. And these are some of the future considerations, people may want to think about. One of the issues is, what do you do if you're, as an arbitrator, you are involved in cases where there are bribery and corruption is involved, and there's contractual bribery and corruption. There are a long line of cases in relation to that. How far does your duty go as an arbitrator? Do you have to investigate it? Then there are other areas, which is the process of crime considerations. As I mentioned earlier, I used to do a lot of white-collar fraud, process of crime type cases. And again, these are now creeping onto arbitrations, and how should an arbitrator deal with that? The other issues that people often talk about is, as you can see with a quick rundown, you've got code for Singapore, you've got code for London, you've got code for International Bar Association, you got Chartered Institute of Arbitrator codes, but you haven't got a uniform code. And apart from modern law, which we looked at. And the question is, can we actually have an uniform, universal code of conduct for arbitrators? There are arguments on both sides of the fence. And some of the arguments, particularly against it, is about how do you enforce it? It's a global issue. Then there are concerns in relation to providing specialist training for arbitrators. That there has been a lot of people who are saying, well, actually, when you're an arbitrator, if you're a judge, you go to a judge school in many countries. You go and train. We should have a specialist arbitrator training, not just as a qualification in arbitration. Then there are concerns in relation to how far does the arbitrator's duties go, where in terms of writing an award, would the arbitrator performing fully and properly if he just writes a very short arbitration saying, yes, I give this award to X, Y, and Z with the damages? Or does it has to be a particular standard? And these are real life issues, because many cases, the quality of the award is very broad, and the reasoning often can go from fantastic to pretty poor, depending on which country and where the arbitrator's sliding scale of expertise comes in. And then, of course, you have the issues of cost and adjournments in many countries. And that again, that goes to the arbitrator. I think is that part of the ability to provide under the contract diligent work, and how far can you push that? So these are the very many issues that are raised in arbitration ethics. And of course, I've only been allocated 30 minutes or so, and I think I've done my 30 minutes. So I will stop for now, and I will, of course, be happy to answer any questions you have through here, or also you got my contact details through KFCRI, and I'll be happy to assist. Thank you to Kavin and to Mr. V.Inbavijayan.
Yeah, thank you, Mr. Ganesan. It was really interesting. Now I think Kavin would continue with the questions.
Thank you, sir. Thank you for all the information.
Thank you, Gavin. Hope you can hear me.
Yes, sir. Yes, sir. Yes, sir. Due to shortage of time, I would like to interact some questions, sir. Before delivering into core of the title, I would like to ask you, how should an arbitrator conduct the proceeding in an ethical manner?
Thank you, Gavin. That's the most important question, and that's the key question of this topic, isn't it?
Yes, sir.
Now, how do you do it in a proper, ethical way? And I think
Yes,
you've got to go back to the slides I put up. Go back to the model law, and go back to what is it required of you. What would a fair-minded observer expect of you? And the key considerations are to act, as I said, in a way that you do not put yourself in conflict of interest. Act in a way which does not give justifiable doubts as to the person's impartiality, independence, behavior, thought process, and so on. And we have had a range of cases, for example, in a very old case where somebody says, I think a particular nationality, don't tell the truth. That sort of bias itself, in terms of thinking, can lead to problems in due course. So when you're an arbitrator, you have to imagine you are being trusted by the parties, and not only trusted, of course, you're being paid, and often arbitrators are well paid to do a case. So in order to do justification to their role, it's a really interesting question, and a good question, and I would say go back to the model law, go back to the international guidance, and there are hundreds of cases in different jurisdictions on challenges to arbitrators, where arbitrators have gone wrong. And one example I gave in the run through, I did that. If you keep getting instructed by the same firm of solicitors or the same route of source of work, then they may give rise to a bias, and that's what often we call the captive arbitrator, which means that as soon as they have a dispute, they'll go to this particular arbitrator.
Thank you, sir. It's been a very explanatory. And the next question is in regards to international perspective, sir. We all know that independence is one discrete factor in the role of an arbitrator. My question is to you is, How is independence as a factor addressed in international arbitration, considering that most countries do not have the red, orange, and green list? And kindly elaborate on the red, orange, and green list for the benefits of attendees, sir.
Yeah, sure. I think in terms of international arbitration scenes, as I said, one of the issues with why arbitration is valuable is it gets rid of those international domestic legal issues from different countries, whether, as I said, a bad example of comparing Zimbabwe with London or Zimbabwe with Dubai. Each country has different process. Now, how an arbitrator applies himself is, of course, depends on the rules on which he is acting under. So you could have an international arbitrator, not only a lawyer, and we know often you have technical arbitrators, often you have engineers, often you have a chemical specialist, or whatever it might be that's a requirement, a wind specialist, a turbine specialist. So they may not have legal training or legal background. So arbitration is unusual in that setting. You know, how do you bring different fields of expertise, professional expertise, and then deliver a standard way of operating? And that's where the International Bar Association guidelines and non-waivable list, where there's a direct link between, for example, you and your employer. That's a very bad example. You know, you shouldn't be adjudicating on a case involving your employer. And often people say, well, actually, that's obvious, isn't it? But then you get many contracts in many countries where the arbitrator is appointed from the government sector, where he's actually working. So these are sort of really the basic, or if you're in a relationship with somebody from that particular institution, you know, those are what we would call a non-waivable list. Whereas there may be other cases, for instance, if you're looking at orange or green, where you may have, as we had in one of the cases, where you may have given an opinion in relation to a completely different case, which has nothing to do with this case. Then you'll be able to say to yourself, well, actually, yes, I am able to disclose, and I am able to say, well, I don't fall in that non-waivable list or potentially waivable red list. But in fact, I'm on a green list where I can actually say, yes, I worked for this particular company or a firm 15 years ago. You know, it's nothing to do with me now. Or to show that you have no financial interest in that particular institution or a relationship or a potential future relationship. So International Bar Association guidelines, it's very helpful in looking at that. Of course, as the word says, it is only a guidance, and it is not anything other than guidance. Okay, so arbitration practitioners, wherever they are in the world, they will have to look at their local guidance, if any exists, but also look at the international helpful guidance from many different institutions, many different societies and organizations that we have. Were you able to follow that, Kavin?
Yes, sir. It would have been really a fruitful information for today, sir. And to the shortage of time, I am asking the last question, sir.
Okay.
Online dispute resolution, or what we commonly refer to as ODR, has gained a lot of attention due to the pandemic. How different is the ethics involved in an online arbitration from a physical arbitration? And can you elaborate on the ethics involved in ODR, sir?
Yeah, sure. Thank you, Kavin. Again, thank you for the very interesting question. ODR, online dispute resolution, is the big topic at the moment, especially with pandemic. Many of the arbitration cases, as I said earlier, have been stopped in their track, and people are finding a way to get that done. The problems it now creates, it's very different to having three arbitrators sitting together in the same room next to each other. Now you suddenly have one arbitrator sitting in one country, another in a different country, and you have got parties sitting in different locations. So it becomes pretty disjointed, but doesn't mean it can't happen. But what it does mean is that the arbitrators themselves have to be even more scrupulous in their approach, because they're not sitting next to each other, for example, in a three arbitrator case, or if they're by themselves, they need to be absolutely scrupulous in their approach to the case, because what is now happening is that often you may not be able to see the demeanor, the way the case is being presented to you, because of the problems and limitations involved in conducting a hearing online. So the essence of arbitration does not change. What changes with ODR, in my view, is the way you conduct arbitration and the practical issues it comes with it. Because one of the things that you could do in an arbitration face-to-face, you could just hand up a document and you'll be able to deal with it if that's the way to do it. But in an online platform setting, it's very difficult for an arbitrator to follow properly, I think. But there have been many successfully conducted cases during the pandemic as well. So the essence of arbitrator ethics doesn't change, but the practical difficulties have changed.
Definitely, sir. Definitely, sir. It's actually an eye-opener for this, sir. And now we are moving to question and answer section, sir. And my first question is, sir, from anonymous person. Marriage Part A, what is your opinion on ethics disclosure schedule in an Indian Arbitration Act?
What is your
opinion on ethics disclosure schedule in an Indian Arbitration Act?
In my view, I think it's excellent.
In your view, sir. In your opinion, sir.
Yes. In my opinion, I think it's great the Indian Arbitration Act, or the Conciliation Act, has been amended to provide much more of a guidance on how an arbitration should be conducted in India. It was desperately needed. The amendments in 2015 and more recent amendments are very helpful. But of course, just with all these new law that comes in, they will be challenged and there will be loopholes that's being filled, particularly by the 2019 amendments. But I think it's a very big stepping stone for India and Indian arbitration law to have a very direct reference to different scenarios and circumstances, which will, going back to this issue of challenges to an arbitrator's importance in terms of impartiality and bias and independence. So I think it's a very good start. I'm really excited to see how the courts are going to interpret it. And I'm more excited to see how the arbitrators themselves practicing in India are going to use it to speed up the arbitration proceedings, to deliver on the arbitrator ethics that I have talked about for the last hour or so.
Thank you, sir. Thank you so much, sir. And we are moving to next question, sir. A question from anonymous attendee. There are young aspirants of arbitration, young advocates who are watching this webinar right now. It would be grateful for them if you could elaborate on the qualities they could develop or possess to become a good arbitrator.
Thank you. I think anybody who wants to become an arbitrator or get involved in the arbitration field, I would deeply encourage that. I think it's fantastic. It's a great field to be in. It is important to understand the differences between the litigation background that often law students and young people get taught, and then to understand how alternative dispute resolution, which of course includes arbitration. There are now, we have the mediation with the mediation developments in Singapore, CIAC. Anybody who's interested in this field, I think it's really important. You first take time out, learn and understand the area. There is plenty of support material available on the internet. There is plenty of institutions that give substantial amount of documents and guidance and resources to become an arbitrator. And I would say work hard, spend time on it, and be dedicated to it, and you will achieve it. And when you do become an arbitrator, you will understand whether you're an arbitrator or whether you're counsel, whether you're guiding party, whatever the role you play, you will find that role to be very fruitful, very engaging, and very satisfactory, because you'll be able to see that as an arbitrator or as a party to the proceedings, that legal part of the proceedings, that you in fact are making changes to people's lives. You're changing changes to delivering that dispute resolution mechanism.
Definitely, sir. Definitely, sir. It's a motivation for young advocates and the arbitrator who are future advocates of arbitrators, sir. And my next question is to be, what are the addition could be made to the code of ethics in order to cope up with the present trend? What can the Indian arbitral institution can adopt from the foreign institution regarding ethics?
Thank you. I think that's a vital question, because now with the setup of Indian Arbitration Council and accreditation of institutions, it is extremely important there is a robust mechanism for not only training arbitrators, but training arbitrators on ethics and training arbitrators on the type of flags that we talked about, whether red, green, or orange, but also making sure learning from different countries, learning from the International Bar Association guidance, learning from CIArb, learning from LCIA, CIAC, and also you have the AAA guidance. They all come with generic principles which we can derive and bring it to life in India. And I think Indian Council of Arbitration, Indian institutions can do a lot to learn from it and to modify it and bring it into a real code of conduct that is observed, adhered, and respected by all arbitrators, and not only the arbitrators, but also by the litigants who are the parties to the arbitration. And if we get to that stage, I think Indian arbitration will really take off, and people will appreciate the added value it brings as a dispute resolution mechanism.
Thank you, sir. Thank you so much, sir. We'll be very sharing. Thanks you for sharing information and present trends, sir. Will be eye opener for the attendees to attend us. And the final question, the last question, sir, for the session. Hello, sir, from Mr. Suman Balaji RV. What could be the possible updates made to the code of ethics in order to cope up with current trend?
In terms of the current trend in arbitrator ethics, as I say in my last slide, there are a number of different areas that you can look at. And one of the things I looked at as right at the beginning on the final consideration slide was corruption, bribery, proceeds of crime, but also whether you can actually have a uniform code of conduct. I am certainly in favor of uniform code of conduct, but I totally understand the problems it would create, and I can understand the difficulties in enforcement it will bring. So the current trend is the world is big. Many different types of arbitration goes on. Many fields of arbitration goes on, and the arbitrator ethics does not change in the current trend. The current trend is arbitration ethics, arbitrator ethics is ever more important than before, because it doesn't matter how good your arbitration procedure is. It doesn't matter how good your arbitration appointment is. It doesn't matter how much money you spend on lawyers, the location, getting an award. If the arbitrator can be challenged on bias or impartiality, then the whole thing goes away. It becomes a waste. So the trend in arbitrator ethics, in my view, is here to stay, and it's becoming ever more important to get that ethics right.
Thank you, sir. Thank you so much, sir. They have been very informative for the attendees who attended. And coming to the end, Ms. Inbavijayan, come to give a vote of thanks.
Thank you, Kavin, and thank you, Muthupandi Ganesan, for enlightening us on the ethics of arbitrator. This happens to be a lot of clarification given by you, the perspective of various arbitration institutions based out of UK, as well as the United Nations models, how the ethics has to be seriously considered. Very simple understanding is that what we found is that a traffic signal, we have to just obey the traffic signal in a similar way. The arbitrator has to avoid when he's looking into red. When he's ready, he has to be in orange. Obviously, the right person, the right ethics is green. That is the takeaway what we realized from this enlightening webinar. And I think this is the code of ethics, what has been guided by IBA also. And fortunately in India, since you happen to be admitted in India also, we are grateful that you have highlighted about this Arbitration Council of India and how it is going to facilitate the accreditations of arbitrators as well as arbitration institution. Very interesting point is the ethics, the neutrality, the unbiasedness, as well as the impartiality. All the three principles, as you rightly pointed out, is also being facilitated or going to be facilitated by this Arbitration Council of India. It's a really, really interesting point what you have put forward. And we are from KFCRI and the team, we are thankful, and we have to thank you exclusively for making your personal effort, coming to your office even during the lockdown in London. And it's very happy to hear from you all the ethics, because the ethics has to come from lawyer, advocate, arbitrators. So, and it will be takeaway for other professionals also who are venturing into arbitration as arbitrator. And with this, I from the KFCRI team, I thank all. Thank Mr. Muthupandi, Ganesan, Mr. Kavin, as well as Sri Nikila. Before handing over to Nikila, I wanted to just give a short sum up for a minute about what we did for during the lockdown period. I think Mr. Muthupandi also would be interested to hear this. We had 8 webinars before Mr. Muthupandi Ganesan has done this ethics. We started with Mr. Francis Xavier, one of the advisory board member who is a present global president of Chartered Institute of Arbitrator. He spoke about the very interesting component of arbitration clauses. Then we had Aaron Dowling, who is a member of the Board of Trustees of Chartered Institute of Arbitrators from Ireland. He spoke about the career opportunities of for practitioners in arbitration. Thirdly, we had a very interesting speaker, Professor Nathalie Najaf from Lebanon. She is an academician in Lebanon as well as in France. She spoke about the procedure, particularly the guerrilla tactics. I think Mr. Muthupandi would be happy to hear the guerrilla tactics. It is a favorite subject for Arbitration Council, how to manage the process in the other side of the perspective of the council, not the arbitrator. And fourthly, during the month of April, we had Professor Christopher Tu of Hong Kong. He was earlier the Secretary General of Hong Kong International Arbitration Center, and he spoke about the commercial mediator, how to become an effective commercial mediator. It was a different subject, but anyway, it was a bridge between the ADR practice. And in the month of May, we started with ODR, wherein a Tanzanian lawyer by name Madeline Kimi, she spoke about the ODR and the virtual arbitration in African continent, followed by Professor Steve, who had an association with ASEAN countries as a Chinese and ASEAN arbitration. And he himself is a founding president of BIHAI, Asia International Arbitration Center. And subsequently, a good friend of all of us, Mr. Ramesh Shelvaraj, as well as Mr. Professor Sundarraju, both of them spoke about the very hybrid aspect of MEDAR as well as the award. Both are very interesting. We had to start with mediation, do the arbitration, or during arbitration also we can mediate. That's what the takeaway from Mr. Ramesh, who is associated with Young CIArb, Singapore International Arbitration Center. And Professor Sundarraju is a leader in arbitration, and he spoke about how to complete an arbitration, the major role of arbitrator, writing the award. With all these combination of 8 webinars, now we had the wholesome macro view, that is the ethics of arbitrators. Thanks, Mr. Muthupandi Ganesan. I have to just, you have to forgive me because I didn't mention about your firm, very interesting firm, Ganesan and Manuraj, which is based in Chennai. And it is, Mr. Muthupandi is like a bridge between the Commonwealth jurisdiction, particularly having offices in both London as well as in Chennai. He's doing all the activities of arbitration in all these 54 Commonwealth countries. I'm not restricting, but anyway, beginning with, he's doing a lot within the Commonwealth jurisdiction. And he is also facilitating the arbitration activities in some of the region where the rule of law is yet to take off. I think the African jurisdiction where some region we have a problem with the rule of law. Even in those places also, Mr. Muthupandi Ganesan is facilitating arbitration along with his main practice of the criminal law. Thank you, sir. I have taken too much of time. I have just swallowed your time of your presentation. And I wanted to just thank this wholehearted support what you have given to our institution. And very interestingly, he's also now been inducted as fellow of KFCRI.
Oh, thank you. Thank you very much.
I'll now hand it over to Srinikila.
Thank you.
Thank you, Mr. V.Inbavijayan. First of all, I would like to express my sincerest gratitude to Mr. Muthupandi Ganesan for this wonderful webinar session on ethics of arbitrators. All the recent judgments and your own analysis were nothing but simply awesome. All the attendees were so much involved in the ethics, and they're just popping up questions in the chat box too. It's a great pleasure for the team of KFCRI to have you as the lead panelist in this webinar session. Hope the attendees would incorporate these ethical principles among themselves and become a successful arbitrators. A bit of logistics before ending the session. As already explained, KFCRI is taking its first step towards online training. We are proudly hosting our first online AAP program, which is Associate at Arbitration program,
Yeah, I think
which is scheduled to be conducted on 7th of June. Program is only for Indian attendees and not foreigner. You can also register for this online program at our official website, which is www.kfcri.org. I will just show you as to how to register in this for this online training. So I'm just going to our official website, which is www.kfcri.org. In which you can find a tab called Accreditation, in which you can go to Arbitration and Associate. This is Associate at Arbitration Practice Program, so you can register in this Associate column. You can see the details for the training program. The course fee will be rupees 5,000 in Indian amount, including the examination fee. You can register for this program like on tapping this Register Now button, in which you should upload your resume and photo and all other details. The scrutiny committee of KFCRI will scrutinize your resume and will accept your application for getting enrolled in the program. Nextly, as already informed by Mr. V.Inbavijayan, sadly, this is the last webinar session of KFCRI's May webinar series. But no worries, we will reach you soon through monthly jurisdiction-specific webinars in which the lead panelist will be expertise from that particular jurisdiction. Hope Global LLP under the aegis of Kovise Foundation would take lead in that webinar session. Also, the attendees can know more about KFCRI and its future events and programs by through other social media platforms like Facebook, Instagram, LinkedIn, and YouTube. As already told by Mr. Inbavijayan, our webinar sessions, the past webinar sessions has been gone on a flow starting from and how to become a good arbitration practitioner till the ethics of arbitrators. So I would request the attendees to see this webinar session right from the date, starting from the first webinar till the 9th webinar, since it is going in a flow. And also, I would extend my sincerest gratitude to all the attendees who made this webinar series a great success for our team. Because of your active participants, we reached the corners of this world. We have been receiving numerous requests and interests from various participants across the globe to be inducted in the panel of KFCRI as arbitrator, mediator, conciliator, and even tribunal secretary. If you have any queries regarding the online course or webinar series, you can anytime write us at kfcri.adr@gmail.com. Last but not least, I would like to extend my heartfelt thanks to Mr. V.Inbavijayan, who provided backbone support for the smooth conduction of all these webinar sessions. Finally, I would like to thank the team of KFCRI who have been working meticulously behind the curtains for the success of this webinar session. Thank you so much all.
Thank you. Thank you to all.
Thank you.
And thanks, Kavin. And
Thank you.